Hello, ladies and gentlemen. I'm Philip Harris, one of the partners in the Wright Hassel Construction Department, and I'm going to take you through today another Law Bites Takeaways session. And the topic for today is the payment bargain and the valuation bargain under construction contracts, specifically in the context of adjudication. So we need to see things clearly, and in the case of S&T UK Limited and Grove Developments Limited, the Court of Appeal through Rupert Jackson gives us a very clear insight into how the court looks at the payments obligation and the valuation obligation respectively. I think that's important. If we see things in a particular way, we can understand them and cope with them better. To give you a sort of silly example, I had a friend who didn't oil his doors, so his doors were always creaking in his house. So I said to him, look, just see the door as a simple machine. It's a mechanism, right? You've got a hole in the wall, you've got hinges, you can lock it with a lock. It's a simple machine. Just see it as a simple mechanism, a simple machine, and then what you do with them, well, you oil them. And from that time on, he's never had any problem with his doors. His doors are always well oiled. So that's the sort of approach, that's the sort of insight that we get from the Court of Appeal in the S&T case to sort of help us focus and understand on this business of the payment bargain and the valuation bargain. So Rupert Jackson says, well, look, firstly, there is a payment bargain. Secondly, there is a valuation bargain, and the payment obligation is an immediate obligation. So under construction contracts, however you get to the notified sum, and there are a variety of ways, so it may be certification, it may be application, it may be a default payment notice, but you get to a notified sum that's due and payable. And then you get to the final date for payment. And once you've got to the final date for payment, that there is then an immediate obligation to make payment. And in looking at the payment obligation, he looked back. This is a 2018 case of the Court of Appeal, and he looked back at the case in the previous year, ICI and Merit Merrill Technology Limited number 2 of 2017, and it's all there. It sets out this payment obligation. But secondly, the valuation bargain, under which the mechanism of the contract sets out how you value the goods, the works, and the services within the contract. And Rupert Jackson says, well, this valuation bargain can be upheld by either the court or an adjudicator or arbitrator. All of them can open up, review and revise. If there's a dispute, open up, review and revise the valuation mechanism and tell you what should be paid under that particular interim valuation or indeed final account. Because the payment bargain is immediate, if no payment notice has been served by the employer or no pay less notice has been served, and the contract operates by an interim application, then the interim application must be paid. But, says Sir Rupert Jackson, Section 111 of the Act, which is the bit that tells us if you haven't put in a pay less notice, you've got to pay up. Section 111 is not the philosopher's stone. It doesn't transmute the sum notified, the notified sum, into a true valuation of the works. That's where we see it clearly. Just because there is a notified sum, and just because you've got to pay that notified sum, it doesn't mean that the notified sum is the right value. So he goes on to say, and therefore, either party can challenge the correctness of the notified sum by adjudication. And he says that clearly at paragraph 92 of his judgment. And he goes on to say at paragraph 93, the payment bargain dictates what must be paid immediately. The valuation bargain sets out the process for reviewing and adjusting the payments which have been made. And because the payment bargain is immediate, the Court of Appeal then concludes that if and only if the notified sum has been paid under the interim payment, then a true valuation adjudication can be brought to challenge that notified sum. So you can still have a smash and grab adjudication to enforce the notified sum if there hasn't been a pay less notice, but that can then be overturned after payment, emphasis only after payment, by a subsequent true value adjudication. And the judge says the adjudication regime does not trump the payment regime. Therefore, you have to, although you can adjudicate over the true value, you have to pay first. The adjudication regime doesn't trump the payment regime. So pay first, pay the smash and grab adjudication if you've got to that stage before you bring your true valuation adjudication. That is very clear by the Court of Appeal. And then I'm just going to go on and look at the next thing really, which is what's called the correction principle. And there's been a case from 2020, J&B Hopkins Limited against Trans Engineering. And this is one of the decisions, one of the judgments of His Honour Judge Fraser in the Technology and Construction Court, where he again upholds the prompt payment obligation. But he says that if there is an interim application, let's say number 10, that interim application can be corrected in number 11 the following month, in valuation number 11 or valuation number 12. So you're not stuck with it. It can be corrected. If it's wrong, it can be corrected in the next month or the following month. And in this particular case, the Hopkins case, a subcontractor adjudicated successfully for payments of interim application 26. But since 26, there had been a series of interim payment cycles, let's call them monthly cycles. And so the main contractor said, look, I'm not stuck with application number 26. It's been corrected in these subsequent payment cycles. To enforce application 26 by smash and grab adjudication would undermine the correction principle. So the judge gets hold of this and says, well, look, the starting point is there has been a successful smash and grab adjudication. The starting point is that the court will enforce an adjudicator's decision, right or wrong, as long as the adjudicator had jurisdiction and there's no breach of natural justice. And he says there are only two minor exceptions to that. One is where there's an admitted error, so the adjudicator says, sorry, I got it wrong. And the second is in a very small category of cases where there is a self-contained legal point concerning the timing or categorization or description of a payment or pay less notice. So if the adjudicator doesn't admit that he's got it wrong, but he has actually got wrong, say the dates on the payment notice, the number of days, or he's misdescribed a payment notice or a pay less notice, then the court could correct. But otherwise, generally speaking, in the vast majority of cases, the court's going to enforce it. But he went on and he said, no, the main contractor is right. There is a correction principle. But even though there is a correction principle, so in subsequent months you can correct the valuation, application number 26 did not become incapable of performance. In other words, you could bring a smash and grab adjudication to enforce it. It didn't become incapable because the payment cycle had moved on. So yes, there is a correction principle, but if you've got an interim application, there's no pay less notice, there's no employer's payment notice to challenge it, you have to pay that application, even though the payment cycle may have moved on. So that's another useful case. And then I'm just going to finish with John Doyle Construction in liquidation against Erith Contractors, another fairly recent case. Now, you may have heard of the Bresco case, where the Supreme Court said even if a company is in liquidation or administration, it can still adjudicate. There's nothing to stop it adjudicating, even though it's insolvent in that way. So we're stuck with that. That's the Supreme Court's decision. But in the John Doyle and Erith case, the court went on to look at what principles do you apply where a company is in liquidation, it has successfully adjudicated, it comes to the court to enforce the adjudicator's decision. What principles do we apply in deciding whether to enforce that by summary judgment? And the judge says, well, there are 5 principles. Whether the adjudication was in respect of the whole of the parties' financial dealings under the contract or just one element. So what he's saying there is if it was a final account adjudication, it may be more likely that the court would enforce it because all the dealings have been considered. If it was simply an adjudication over one operation under one element of the contract, perhaps less likely to enforce it. Secondly, whether there were mutual dealings between the parties outside, beyond the construction contract. So if there's a cross-claim under perhaps another contract or for another reason, if there were other mutual dealings beyond the construction contract that had been adjudicated, that might go against enforcement. Whether there were other defences which could now be raised on the summary judgments issue, which hadn't been raised in the adjudication. That's the third. Are there other defences? Fourthly, whether the liquidator was prepared to offer undertakings or to ring fence the amount of the adjudication decision or to offer security. So what the court's concerned with there is that there's a paying party, somebody who's been ordered to pay, but he may have a genuine cross-claim which he subsequently wants to bring to the courts. If we, the courts, order payments under this adjudication, is that going to preclude, is the money just going to disappear into the company in liquidation? And when the cross-claimant brings his cross-claim, there's no money for him to get at, so the money's disappeared. So if the liquidator will offer security or ring fence, that's a factor to be taken into account. That's number 4. And number 5 is very, very similar, whether there was real risk that the enforcement would deprive the paying party of security for his cross-claim. So the court helpfully sets out those 5 principles to take into account. So that's just a quick gambit through some of the relatively recent law on payments and valuation and adjudication, and I hope you found that helpful. Thank you very much.